Welcome to the Connecticut Caselaw podcast. I'm Jay Ruane of Ruane DUI and Criminal Defense Attorneys. This week we are covering decisions released on judicial, ending the week of August 14, 2026. Let us get into it. The next case is B v. RH Equity Holdings, LLC. This is a business and commercial dispute involving an arbitration clause in a limited liability company agreement, and it gives us a genuinely useful roadmap for a recurring problem. Who decides whether a claim is even arbitrable in the first place? Here is what happened. Eric B. is a Connecticut radiologist who had ownership interest in Radiology Associates of Hartford. In March 2022, as part of a larger purchase and sale transaction, B signed the limited liability company agreement of RH Equity Holdings, LLC. That agreement included a non-compete clause barring him from competing within a defined geographic area for 2 years after leaving. It also included an arbitration clause that incorporated by reference the American Arbitration Association's commercial arbitration rules and limited the arbitrator's authority to money damages, attorney's fees, costs, expert witness fees, and sanctions for abuse of the arbitration process. B resigned in April 2024 and went to work for Radiologic Associates of Middletown. Shortly before his resignation took effect, the defendants filed an A2A arbitration action seeking a declaration that the non-compete clause was enforceable and that B's new employment violated it. That is it. No claim for money damages, no claim for injunctive relief, just declaratory relief. B responded by filing a declaratory judgment action in Superior Court and moving under General Statute Section 52-407G to have the court determine arbitrability. The trial court, Judge Smith, agreed with B on both issues. First, the court held it had authority to decide arbitrability because the parties had not clearly and unmistakably agreed to delegate that question to an arbitrator. Second, the court held the defendant's claim was not arbitrable because the arbitration clause did not empower an arbitrator to award declaratory relief. The AAA dismissed the arbitration, and the court entered final judgment for B. The defendants appealed, and the appellate court affirmed. Judge Westbrook wrote the opinion, joined by Chief Judge Cradle and Judge Elgo. The first issue was who decides arbitrability. The agreement selected Delaware substantive law, so the court applied the Delaware Supreme Court's framework from James and Jackson, LLC versus Willigary, LLC. Under that framework, incorporating the AAA rules can be clear and unmistakable evidence that the arbitrator decides arbitrability, but only when the arbitration clause generally provides for arbitration of all disputes. When the clause is more limited, incorporating the AAA rules alone is not enough. Something more is needed to clearly and unmistakably show the parties intended to send arbitrability to the arbitrator. Here, the arbitration clause was not broad. It used the word unresolved to modify what disputes were covered, suggesting arbitration was not the sole avenue. It expressly capped the arbitrator's authority to 3 specific forms of relief, and it carved out injunctive relief for court adjudication. That combination the appellate court held meant the clause did not generally refer all disputes to arbitration, so the rule incorporation alone was insufficient. The court properly decided arbitrability itself. The second issue was whether the defendant's declaratory relief claim was arbitrable at all. The court said no, because the arbitration clause expressly limited the arbitrator to money damages, fees, expert witness fees, and sanctions, and contained no authority to award declaratory relief. Any declaratory award would exceed the arbitrator's powers and be subject to vacatur under Section 52-407W. When declaratory relief is the only claim in the demand, and declaratory relief is not among the remedies the arbitration clause authorizes, the claim falls outside the agreement entirely. The practice takeaway here is direct. When you are drafting or reviewing arbitration clauses, the scope of the arbitrator's remedy authority matters enormously, and so does whether the clause carves anything out for court resolution. If your clause limits remedies and creates exceptions, you may have inadvertently made the clause narrow enough that courts, not arbitrators, will decide threshold arbitrability questions. And if a party drafts an arbitration demand seeking only declaratory relief without checking whether the clause even permits that remedy, they may find themselves bounced out of arbitration entirely. Draft with specificity and read the remedies provision before you file. The next case is Bellamy versus Commissioner of Correction. This is a habeas corpus appeal arising from a murder conviction. Brandon Bellamy was convicted after a jury trial of 2 counts of murder: first-degree assault, criminal possession of a pistol under General Statute Section 53A277C, and carrying a pistol without a permit under General Statutes Section 2935. He received a total effective sentence of 100 years. The critical issue at trial was identity. The state's primary evidence was the testimony of a single eyewitness, identified in the opinion only as D, who looked out a second-floor window in the early morning hours after a shooting and said she recognized Bellamy standing in the street. There was no physical evidence tying Bellamy to the scene. No fingerprints, no DNA, no recovered weapon. Bellamy filed a habeas petition alleging that his trial counsel, Glenn Conway, rendered ineffective assistance on 4 grounds: failing to consult with or call an eyewitness identification expert, failing to object to the jury instructions on identification, failing to pursue a third-party culpability defense, and failing to call witnesses to refute the state's motive evidence. The habeas court denied the petition on all 4 grounds. Bellamy appealed, and Judges Suarez, Wilson, and Pellegrino affirmed. On the eyewitness expert issue, the court pointed to a straightforward but important timing principle. At the time of Bellamy's 2010 trial, the controlling authority was State versus Kemp, which generally disfavored expert testimony on eyewitness identification as an intrusion into the province of the jury. Our Supreme Court did not overturn Kemp until State versus Gilbert in 2012. The appellate court said Conway cannot be faulted for following the law that existed at the time. And regardless, Conway had cross-examined D extensively on all the same factors an expert would have highlighted: the lighting, the distance, her viewing angle, her emotional state, and the 2-year gap between the shooting and her identification. On the jury instruction claim, the court found the claim failed for lack of evidence. Bellamy never introduced alternative instructions he claimed should have been given, never specifically questioned Conway about which portions of the charge were deficient, and never established that a different instruction would have produced a different result. The instructions the trial court gave tracked the standard model charge and incorporated the key tell-fair factors. That was sufficient. On third-party culpability, Bellamy argued, Conway should have pointed the jury toward a man named Boone, whose cousin testified at the habeas trial that Boone had possessed the same 9mm Glock used in the shooting about 3 weeks before the murders. The habeas court did not find credible that the cousin would have implicated Boone if Conway had questioned him in 2010. The cousin had not previously identified Boone. Boone had died before the habeas trial, making him a convenient target, and the 2 men were relatives. The appellate court agreed that Conway's decision was sound trial strategy. He had investigated and could not find any evidence connecting a third party to the actual shooting. Without that direct connection, the evidence would not have been admissible under Connecticut's third-party culpability standard, and the petitioner could not establish prejudice. On the motive witnesses, the state had argued at trial that Bellamy shot the victims in retaliation for losing a fight at a nightclub earlier that night. Bellamy presented witnesses at the habeas trial who said they never saw an altercation. But Conway had reviewed video footage from the club that showed a physical confrontation between Bellamy and one of the victims. More importantly, the witness who described the altercation at trial had also testified that he never identified Bellamy as the shooter. Conway made a reasonable strategic call not to attack a witness who was actually helping the defense on the key identification issue. The practice takeaway here is about timing and the law at the moment of trial. When you are evaluating an ineffective assistance claim involving a legal theory that has since evolved, the standard is what a competent attorney would have done under the law as it stood then, not as it stands now. Gilbert changed the landscape on eyewitness experts in 2012, but that did not make Conway deficient for following Kemp in 2010. Document your strategic decisions, especially when you are making a calculated choice not to call an expert or pursue a particular defense. The record Conway built on cross-examination of the eyewitness is exactly what saved him in the habeas proceeding. The Connecticut Caselaw podcast is brought to you by Ruane DUI and Criminal Defense Attorneys, Connecticut's statewide criminal defense firm. We gladly accept referrals of criminal and DUI defense cases throughout Connecticut. In Fairfield and New Haven counties, call 203-925-9200. In Hartford County and Eastern Connecticut, call 863-925-9200. Always available online at ruinattorneys.com. Now back to this week's decisions. The next case is Jordan v. Commissioner of Correction. This is a habeas corpus case out of the Appellate Court decided by Judges Cradle, Elgo, and Clark. The petitioner, Victor Jordan Sr., had been convicted of aggravated sexual assault in the first degree. His central claim on habeas was that the trial court violated his due process rights under State v. Wang by denying his request for state funds to hire a private investigator while he was self-represented. The habeas court found against him, but not before making a critical procedural ruling in his favor. The habeas court concluded that the commissioner had abandoned the procedural default defense by failing to argue it in the post-trial brief. The habeas court then went on to the merits and still ruled against Jordan. The appellate court took a different path entirely. It reversed the habeas court on the abandonment question, found the Wang claim procedurally defaulted, and affirmed the denial of the petition on that basis. Here is the core of the ruling. The commissioner had raised procedural default in his return as required by Practice Book Section 2330. Both parties elicited testimony about it at trial. Jordan addressed it in multiple briefs. The appellate court held that once procedural default is properly alleged in the return, the burden shifts to the petitioner to prove cause and prejudice. The commissioner is not required to re-argue the defense in a post-trial brief to keep it alive. The defense was squarely before the court, and that was enough. On cause and prejudice, Jordan argued that Wang was decided the same day this court affirmed his direct appeal, so there was no procedural avenue available to him. The appellate court rejected that. His appellate counsel, attorney Pamela Nagy, testified that she actually knew a Wang-type claim existed and made a strategic decision not to raise it. Beyond that, Jordan's case was not yet final when this court affirmed his conviction. He still had time to file a motion for reconsideration with the appellate court, and he did file a petition for certification to our Supreme Court. He raised neither avenue to advance the Wang claim. The court said he offered no persuasive reason why he could not have done so. The practice takeaway is straightforward. If you represent the commissioner in a habeas matter and you have raised procedural default in your return, brief it anyway at the post-trial stage. The appellate court affirmed here and even noted that the commissioner's failure to brief it below was not fatal, but the court explicitly encouraged future post-trial briefing on that defense. A clean record on procedural default protects the ruling at every level and avoids the kind of ambiguity the habeas court relied on to find abandonment in the first place. The next case is Office of Chief Disciplinary Counsel versus Vaccaro. This is an attorney discipline case with an unusual procedural posture. It involves two separate tracks of proceedings against the same attorney, Enrico Vaccaro, and the question on remand was whether the Supreme Court's ruling in one track rendered the other track moot. Here's the background you need. Vaccaro was suspended from practice for 90 days based on findings that he failed to act with diligence and to communicate with a client in a personal injury matter. As part of that suspension order, the trial court told him not to disperse funds from his IOLTA account. Afterward, he violated that order by writing checks to himself. That triggered an audit. The audit revealed a balance of about $226,000 sitting in the IOLTA account that could not be traced to any client file or to fees Vaccaro had earned. The trial court eventually ordered those funds returned to Vaccaro. The Office of Chief Disciplinary Counsel appealed, and the appellate court reversed, holding that the record was devoid of any evidence the funds were earned fees, that Vaccaro had not met his burden, and that the funds should escheat to the state under General Statute Section 361A and Rule 1.5 of the Rules of Professional Conduct. Meanwhile, in the separate due process track, Vaccaro had argued that delays in the underlying grievance proceedings resulted in a denial of due process. The Supreme Court ultimately reversed the appellate court in that track and remanded to give Vaccaro a chance to litigate his due process claim as if he had timely appealed the grievance committee's decision. Vaccaro then argued to the Supreme Court that because the judgment in the due process track had been reversed, the IOLTA escheat ruling had to fall with it. He claimed the escheat order was built on the premise of unchallenged misconduct, so once that premise was in dispute, the IOLTA judgment was moot. The Supreme Court granted certification on that question and sent it back to the appellate court to decide. Judges Cradle, Elgo, and Maul, in a per curiam opinion, rejected that argument. The court drew a clean line between the two proceedings. The misconduct finding arose from how Vaccaro handled a personal injury client. The IOLTA audit arose from his violation of the court's disbursement order and the unexplained funds sitting in his trust account. Those are separate legal questions with separate records. The reversal in the due process case did not touch the audit, did not affect the evidence about the $226,000, and did not disturb the legal analysis under Section 361A or Rule 1.1. The court held the IOLTA appeal is not moot. Its earlier judgment stands, and neither that decision nor the trial court's underlying ruling should be vacated. The practice takeaway here is straightforward but important. IOLTA account discipline has its own legs. Even if underlying misconduct findings are reversed or remanded on due process or procedural grounds, violations of trust account obligations and disbursement orders are evaluated on their own evidentiary record. If you cannot affirmatively show where funds in a trust account came from, you cannot claim them. The burden is on the attorney to demonstrate that unallocated IOLTA funds are earned fees, and the absence of that proof is itself sufficient for an escheat order to stand regardless of what happens in parallel misconduct proceedings. The next case is State v. Newton. Dennis Newton was on parole when Waterbury police and parole officers searched his mother's apartment where he was living. They found cocaine, a scale, and a firearm. Newton moved to suppress, arguing he retained a Fourth Amendment expectation of privacy in his home. The trial court denied that motion, finding he had waived any such expectation by signing his conditions of parole, which required him to submit to searches at any time, announced or unannounced, with or without cause. Newton then entered a conditional nolo contendere plea under General Statute Section 54 to 94A, preserving his right to appeal the suppression ruling and a motion to dismiss for insufficient evidence. The appellate court, in an opinion by Judge Alvord joined by Judges Clark and Westbrook, affirmed on the suppression and motion to dismiss issues and declined to reach the motion to compel. On suppression, the court applied Sampson v. California and held that Newton had no reasonable expectation of privacy in his residence. He had signed parole conditions expressly requiring him to submit to searches of his person, possessions, and residence. His mother, as his parole sponsor, had also agreed to searches of her apartment. The court said the trial judge correctly concluded that under the totality of circumstances, including Newton's parole status and the plain terms of the search condition, no cognizable Fourth Amendment interest existed. The court also pushed back on Newton's argument that the trial court's use of the word standing was improper. explaining that courts regularly use that term as shorthand for the reasonable expectation of privacy inquiry, and that using it here made no legal difference. The court declined entirely to reach Newton's motion to compel claim. Because he pleaded nolo contendere under Section 5494A, the only issues available on appeal are whether a motion to suppress or a motion to dismiss was improperly denied. A motion to compel disclosure is not on that list, and the court said it had no authority to review it in this posture. On the motion to dismiss, Newton argued the state lacked sufficient evidence to proceed because it had no confirmed lab results from the state forensic lab, only field tests. The court disagreed. It confirmed that on a pretrial motion to dismiss, the state only needs to establish probable cause, not proof beyond a reasonable doubt. Field tests conducted by law enforcement that return positive results for narcotics are sufficient to support probable cause at that stage. Newton's reliance on State v. Gale was misplaced because Gale addressed trial sufficiency, not the pretrial probable cause standard. The practice takeaway is straightforward. If you have a client on parole who signs a standard search condition, do not expect the Fourth Amendment to be a viable suppression argument absent a search that falls outside the terms of that condition. The appellate court was clear that the scope of a parolee's privacy rights is defined by what the conditions actually say. Where the condition covers the residence and the search complied with it, the analysis ends before you even get to reasonableness balancing. Your best argument in that scenario is that the particular search exceeded the scope of what the parolee agreed to, not that the condition is insufficient to eliminate privacy rights altogether. That is all for this week's Connecticut Caselaw podcast. New episodes every Friday. Subscribe wherever you listen to podcasts, give us a 5-star review, and we will see you next week. This podcast is for informational purposes only and does not constitute legal advice. This episode was written and voiced using artificial intelligence. Please read the full opinions yourself before relying on anything discussed here.